I'd like to welcome everyone to today's webinar. I'm really excited we're able to put this on. One of the reasons why I wanted to put this on is because, as many of you know, at the beginning of the pandemic, when they had to close the courts, families were really struggling with what to do about parent time, what to do about high-risk individuals, and what to do about having emergency matters heard. So we were finally able to get this organized and get it going. I'm really pleased for our two speakers today. We have Commissioner Russ Minas, who is an alum of our great law school, and he graduated in 1989. Prior to his appointment to the bench in 2018, he practiced family law in Salt Lake for 29 years. During this time, he served as staff attorney, domestic violence program director, and executive director at Legal Aid Society, which is where I first met him. So we have that really fun link in common. He was listed on the Utah Court's ADR roll as a master mediator for domestic relations, and in 2013, he was recognized as the Utah State Bar's Family Law Attorney of the Year. Our other participant is Sharon Donovan, who has practiced law for over 40 years, primarily in the areas of family law, ADR, and litigation. She's recognized as a leader in the family law community in Utah and has been probably since the time she first began practicing. She's so amazing. Sharon is a strong advocate who uses experience and common sense to resolve problems. What we would like to do to begin this program is first we will hear from Russ, who will talk to us about what's happening with the courts and some of the problems he's seen, and then we'll turn it over to Sharon. So Russ, I'll let you take it from here and make sure you turn off your mute.
Okay, can you hear me?
Yes.
Okay, very good. All right, well, thank you everyone. I gave a talk similar to this back in May, I want to say, when not long after after COVID hit, and we were still in this place of trying to figure out how we were going to proceed. And we had almost right away received standing orders from the Supreme Court. And I think all of those orders also went out to the members of the bar through the Utah State Bar's email system as well. And there was a lot of confusion back then. Nobody really knew what to do. I'm reading through these, through the emails with these pandemic orders that were coming out of the Supreme Court, and it led me to believe that we would only be handling mission critical types of proceedings. And at that time, the language read, it read, at least to my eyes, that we should only be hearing matters like TROs, protective orders, and other critical issues that were in effect emergencies only. So early on, I was striking hearings in March and April that were COVID related and just continuing them and kicking them down the road. And part of what came out of that as well, because I see motions for temporary orders, people don't have, they're in a state of limbo with respect to how they're going to divide up their parent time. And in order to prevent chaos from reigning, what I'll do is I'll share a screen first. This began really out of the 2nd District from the 2nd District Court Commissioners. And let me put this up. This was an order that we sent out or put into the notices that the courts tried to give the parties some type of ground rules to proceed until their matters could be heard. And a lot of you may have received some version of this. These were sent out for quite a while. I don't know that there is a need to do that so much anymore because we're pretty much back up and running remotely now at this point. Also, what we were sending out were these AFCC pandemic guidelines, and I think this is good. I think this still applies today. And all these documents will be sent to the participants today after the presentation is concluded. So what I wanted to say was that, and I'll unmute, or I'll take this down for a minute. I'll leave it up for a minute and then I'll take it down. But what I wanted to say was just thank you to everyone first, and just I think most attorneys have adapted really well. I think there may be some confusion still on different commissioners, different judges doing things differently, and I recognize that's happening. There's certainly a different levels of comfort when it comes to using new technology, and some people are just eagerly invited it and we're up and running, and others are not. There are other ways of handling hearings remotely through telephone, for example. In the 3rd District Court, I think I'm really the only one that's using Webex as a general rule, and my other 3 commissioners here in downtown are mainly conducting their hearings, if not all of their hearings, by telephone. I'll break it down just a little bit as to what I'm doing is if it's not protective orders, or if it's not the pro se calendar that we have, which some of you are familiar with, I'm handling all my hearings via Webex at this time. It's an ongoing, it's evolving over time. The program that the version of Webex that the courts are using was designed specifically by Cisco for the Utah State Courts. And so improvements are being made all the time. One of the frustrations I've had, especially with the pro se calendar, is the inability to link up attorneys and pro se litigants and get them into chat rooms where they can talk to each other. And I think some of that is still in the works. Judge Mrazek up in Park City has been using Zoom for that purpose, and has been able to send people, so effectively say, go out in the hall and talk, and let people go into chat rooms that were created by Zoom. I think just some best practices, it's helpful to go over, but first an acknowledgement that these remote hearings, they really fall short of the gold standard of in-court hearings, and I acknowledge that. There's really little opportunity to assess demeanor, which is helpful even during a proffer hearing. You can observe people who may be trying to stare down the other party, their body language, that sort of thing that might give you some indication of where credibility may lie. And the other thing that you get in a courtroom that you don't always get with remote transmission and video is you know who's in the courtroom. And when I'm conducting a video hearing, I have no idea who's sitting across the screen from the camera, who's out of view of the camera. It could very well be that there's a child of the parties that's sitting across the table as a pro se litigant is calling in. And so that's problematic as well. Just in terms of good best practices, I think first and foremost, it can't be said enough, just having a decent internet connection. And I'll also acknowledge that some of the problems with the internet connections also come out are at the court's end as well. The court uses CenturyLink, and sometimes that goes down, and sometimes it's slow. And if we have 30 courtrooms going at the same time, that can be a problem as well. For the most part, I think the court connection, at least downtown, has been good. I've heard different stories maybe out of West Jordan, and I think Commissioner Tack and Commissioner Ito also signed up for this presentation today. I wish in some ways perhaps we can unmute them, but they could certainly chat in as to what they may be doing, and we can share that as well. Also, when people chime in, sometimes I can't tell who it is. If they're certainly, this is more of a problem with pro se litigants than it is with attorneys, but if someone's calling in by phone and that's all they're doing, all it says at my end is phone user phone user 1, 2, 3, 4, etc., and then only the first 5 or 6 numbers of the email, or excuse me, of the phone number. So it's difficult sometimes when there's several people that are calling in by phone and you're trying to ask them to identify themselves and they all speak up at once, or even if they don't, then you're watching the list of phone users to see whose audio appears to be moving. The speaker icon is moving, so then you can go in and perhaps change their name and identify them. So when you log on, it helps clearly if you have an ID name that clearly identifies yourself. That makes it a whole lot easier. Certainly if your video's on, that's also very helpful as well. Another problem that I have when I'm conducting hearings is that there can be feedback loops, echo, and that comes from people who are using speakers rather than headsets. So they'll have either a speaker and a separate microphone, or they'll be using the speaker that's built into their webcam. And sometimes what happens when that, especially if you're using speakers and a separate microphone, you'll get this feedback that will occur, and it becomes this nightmare as far as trying to hear the audio. So then I'm having to use my mute features. We'll stop the proceedings. We'll ask people to adjust their settings accordingly. Turning down speakers sometimes helps. Sometimes people call into or join the conference, and they're not. We can't hear them because they haven't activated their microphones. In Webex, as you run your mouse over towards the bottom of the screen, there's a circle with 3 dots in it, and you may need to go in and activate your microphone so that we can hear what's going on, and you can speak up if you need to. And so this has been problematic too. Worst comes to worst, if we can see somebody but we can't hear them, we can have them call in, and they can have their audio, their microphone through their telephone, and we can still see the video there. It's important to mute yourself if you are talking while other hearings are in progress. There have been several instances where attorneys and clients will start talking with each other during the hearings, and then they forget to mute themselves. I have some control over that, but again, it's a disruption to the hearing, and we have to sometimes stop and try to figure out who the culprit is, and then be able to fix that and move on. Using the chat features, that's what we do. What I do when I go on is I prevent the participants from chatting directly with me. I think that's important for obvious reasons in terms of attempts at ex parte communication with the hearing officer. But also be careful. If you want to speak with your client via chat, then there are people who have chatted to all. And so sometimes there is what was intended to be a confidential communication is made available to everyone else who's a part of the hearing, even those people that aren't on the particular case that's being heard at the moment. And let me just get down here too. I'll just let you know one thing I've been doing with respect to Rule 101H3. I'm talking about the rule that what to do if you have voluminous exhibits that you want heard. And in the past, the way it would be handled before COVID, at least under the rule, the way it was supposed to work was that you would do your summary of exhibits under the rule, and then you would serve the paperwork on the opposing party, and then you would bring the binder of exhibits with you to the court hearing to give to the commissioner for use during the hearings. Well, obviously we're not having in-court hearings. I'm fine with binders coming in. That can still happen. They can be delivered to me before the hearing, and I can use them remotely during the hearing. But what I'm also letting people do is, as long as they have their summary of exhibits in and they serve it on the other party, if you can go ahead and put your exhibits, you can PDF them and put them in the court file. I'm okay with that. What I prefer certainly is if they're bait stamped. With Acrobat Pro, you can electronically bait stamp your document. Then I don't have to sift through perhaps 150 pages of materials trying to figure out what page I need to go. Another issue that arises is interpreters. When interpreters are involved, and that happens a lot during protective orders, it happens a lot during the pro se calendar, and it also happens on the regular law and motion calendars where attorneys are involved. But we send out notices to the interpreters when people request them. If you need an interpreter, you should request it, and then we can go ahead and get notice out. If it's a WebEx hearing, the interpreters will join, they will have the link, and then when in court before, we would try to get an interpreter for both parties, and then they could interpret on the fly as the hearing is going on. and we could just proceed without having to pause. But that's not really working out that way here. There's some cases where if there's only one party needs an interpreter, then we can mute them. They can get on the phone with each other, and then the interpreter can interpret on the fly as well. But in most cases, you're going to have one interpreter. You'll need to speak in short sentences and then pause, let the interpreter translate, and then we'll go back, and then we have to carry on that way. So that can substantially add time to the length of a hearing. But as I've been saying a lot lately, sometimes you just got to make do. So we're doing the best we can with that. I did mention briefly, I'll say a little again, with protective orders, what I'm doing is I'm still conducting those by telephone, and we are calling the parties. We send out notices ahead of time saying that indicate that the court will be calling you. If you don't have an email address, or well, if we don't have your telephone number, we put in the notice. Part of the reason you may be receiving this request, if you're receiving this request in the mail, it's because we don't have a telephone number for you or an email address for you. We would have emailed it out. So if you have any questions, you can email my team, and then we will call the parties at the time of the hearing via conference call. And that's still sometimes problematic when someone doesn't pick up their phone. It happens with Webex too. They don't join. And the question is that intentional, or are they trying to join but they can't? With the protective order calendar, I start at 9 o'clock. I have a 9 o'clock calendar and a 10 o'clock calendar, and sometimes I don't finish until 1 o'clock in the afternoon. And so our notices also say that you may not get a call from the court for up to 2 or 3 hours after your time set for a hearing. And I don't know, sometimes people may not be continue to be available, and so we call them late and they don't pick up. We leave a message, and then we just proceed. We do the best we can, but I think I'm much more amenable to motions to set aside for those types of reasons. I talked a little bit already about chat rooms. That's something I'd really like to do with the Pro Se calendar. Pro Se calendar we're still doing by Webex, and we'll continue to do that until the way we have been, until we can get chat rooms where I can line up attorneys and parties and stick them in the same room together. One thing that I'm seeing a lot right now is that I'm getting a lot of requests for temporary restraining orders right now regarding school attendance. And we have most of these situations arise when there's joint legal custody and there's no final decision maker, and one parent wants the children to be attending school and the other is concerned that it's not safe for the children to be attending school, and so they want it to be remote. I'm dealing with a lot of that right now, and really it's case by case, but the competing interests, of course, are the falling behind in educational development versus safety. I'll just touch briefly on video trials. I don't conduct evidentiary hearings, but I did talk with Judge Mrazek about how he was doing it. And one of the things he's requiring is with exhibits is that the parties mark their exhibits and PDF them, or they can certainly leave them in hard binder form. The original exhibits will need to be in hard binder form or in hard form, and then getting those marked exhibits to the witnesses ahead of time. And then when the witnesses join the hearing, having them sworn, and then moving them into the lobby where they can't talk to each other. I think they're the same kind of issues I talked about earlier about observing the demeanor of the parties is the same kind of issues that arise with taking testimony of witnesses as well. Some of my concerns also continue to be, and I'm trying to be mindful of all this, fairness to everybody. Am I prejudiced against someone who joins and there's no video because I can't see their face? Is that something that's subconsciously happening? Am I being fair to the indigent, the non-English speaking people, the people with poor internet connections? And these are the things I'm always trying to keep in mind as I'm conducting my hearings. And That's about, we're about 25 minutes into it, Lori. I think Sharon has about 20 minutes as well.
She does. And
Okay.
what I want to do is say, as we all go through this process, Sharon and I noticed our blood pressures going up when we were having technology problems.
Mm-hmm.
So we all have to be a little patient because things happen and it doesn't always go as smoothly as we want. And this isn't the first time and certainly won't be the last time when there are technology issues. So we have to be cognizant of that. Because we were having technology issues, I forgot to tell everyone that at the conclusion of the speakers, we'll be answering questions. So please use the Q&A feature. There's one question now, so everyone that is watching can look at that question and vote it up so it can go to the top. But right now there's only one. We will answer those questions at the end. So please use the Q&A and not the chat. Thanks. Okay, Sharon, with that, turn it over to you.
Okay, thanks, Lori and Russ. I really appreciate the opportunity to speak to you all. I think, as Lori said, one of the things that is really important from a family law practitioner's point of view, and probably from the court's point of view, is to have some patience and some flexibility, because I think as I've done, court hearings, as I've done mediations, collaborative family law through Zoom, inevitably, there's always some problem, some technical problem with somebody. And I think that's just part of the deal that we need to understand. And, we just need to work with it. And I think as everybody gets more used to it, I think some of the bugs will be worked out. So I've been asked to kind of talk about the pandemic from the practitioner's point of view. And, I'm sure we never thought 4 or 5 months ago that we would be operating our law practices and our court hearings through screens. Back in March when people were thinking about spring break and all of those things, little did we know where we would be now. And I think we've come a long way. So we've been in this since mid-March, and everybody's been trying to figure out how to keep their practices going, how to keep their clients happy, how to keep their staffs motivated and reassured, and also how to take care of ourselves. It's been a huge challenge, and on top of that, we had an earthquake. And I just remember that day in March, working from my dining room table. We had already had the earthquake, and I was talking to a client, and then all the aftershocks were happening as I was talking to him. And it's really hard to keep it together when all that is happening and be reassuring and knowledgeable. And so it has really, really been tough. A couple of points that I wanted to make, and as Lori, I think, indicated, Russ and I have outlines that will be sent out to you afterwards. So I think the biggest concern, particularly if you're a solo practitioner or in a small group, or if you're one of the senior partners of 30 people, is holy Hannah, Helen Christian used to say. What are we going to do? Are we going to be able to keep practicing? Are we going to be able to pay our employees who have been with us for 30 years? Are we going to have clients? And what has been a very overwhelming experience for everyone. And what we've learned is we've done pretty darn well. I think everybody has really stepped up. And from the practitioner's point of view, we need to reassure our clients and also be knowledgeable ourselves to the extent that we can be, so that we can continue to effectively represent our clients, and also trying to keep ourselves sane in the meantime. We've been to seminars over the years about, what to do if there's a disaster, And, you know, maybe we didn't really pay that much attention. What happens if there's an earthquake and we lose all our files? And, you know, what do we do with that? And I look back on those days, and maybe we should have listened a little bit better. But in our firm, thankfully, we had changed our phone system so that we could roll calls over out of our office, and people could be working remotely, which was a godsend. And so what I would suggest, and I hopefully a lot of you are doing this, is number one, we need to look after ourselves. And one of the articles that I read that's in the materials that I'm going to recommend to you, you don't have to write it down, it's on the outline. Lawyer Monthly put together an article, Family Law Lawyers' Advice to Law Firms Coping with COVID-19. And one of the things they said, because everybody's freaking out about, are we going to have clients, are we going to have ongoing business, is to overschedule ourselves. You know, I remember in the early days, I had conference after conference after conference because, you know, I didn't really know what else to do, and I didn't know what was happening. And I think that, or what was going to happen. And I think probably a lot of people have experienced that. And so now that things have calmed down, I think, you know, let's try not to overschedule. I think that people maybe should take a walk during the middle of the day, whether you're working remotely at home or you're working in the office. I think that that is really, really important. And so what we have done in our office, and again, at the beginning, I think everybody just sort of froze because they didn't know what was happening, and people who maybe were in a terrible relationship didn't do anything because they didn't know what was going to happen. And then we had the earthquake, and then, you know, a month or two went by, and now the phones are ringing off the hook. You know, they say that the hairdressers and the divorce lawyers are the ones that have the most business. And, you know, I think that there's a lot of truth to that, that people now understand that this may go on for quite some time. And people are either really working well in their relationships and really, you know, looking at the positive, staying home, cooking, you know, whatever they need to do to keep their families going home, teaching their children, whatever they're doing. And then there are other people that they can't stand it one more minute. And so we are, I think most people, I don't know, are seeing an increase in phone calls now. And what I would suggest that your support staff do, or yourself do, when answering calls and scheduling clients, is to be reassuring to clients that we are still in the business of practicing law. We are deemed essential services, and we can do this. We've had to change how we do things with the courts being, you know, basically closed for a period of time, and now dealing with the backlog and, you know, what cases are getting priority. So I think the narrative is we can do this, and the narrative to our staffs and to ourselves would be we can do this. It's different, but I think we need to be reassuring that we can continue to do our jobs and maybe do them differently, but do them efficiently, and maybe even more efficiently, frankly. And what happened at the very beginning, there were several mediators that really jumped in and figured out how to do Zoom, how to do mediations. And there are some mediators that I don't think want to go back to the old days because it's actually more efficient, maybe not quite as personal, but more efficient. We're getting mediations done at 3 o'clock in the afternoon and documents signed, whereas before, you know, we might go till 10 o'clock at night because we had all the time in the world. And so we can do this. The other pitch that I wanted to make is that for those who are trained as collaborative lawyers, or who might want to be trained as collaborative lawyers, some of us have used that as a way to help clients get problems resolved through a collaborative process because we can't get into court anyway. And it's a much better process. And I have more collaborative cases now than I ever have. And we do 4-way meetings via Zoom. We can do all sorts of things in a much more peaceful way to help people with their problems. And I think it's a much better product. The other thing I wanted to mention, that one of the American Academy of Matrimonial Lawyers, a fellow out of California, Christopher Melcher, has done a webinar for the AML. And I have this in my outline too, so you don't have to write this down either. It's on YouTube now, how to do a virtual hearing. And it's about an hour-long presentation about some of the things Commissioner Minas was talking about, the problems with not knowing who's in the room, of talking back and forth, sending text messages when you're not supposed to be. Some of those problems, I would recommend that you watch this webinar because it was very helpful to me to try and figure out, how do we get exhibits in? How do we mark them? How do we do all those things? We're doing depositions by Zoom too. We can take depositions now. The court reporters know how to do it. The other thing that I also wanted to mention in terms of the court hearings, as Commissioner Minas mentioned, the courts have decided to do these by Webex. And, one of the things that we have to be careful of as lawyers, that we continue to be competent. And one of those competency requirements is to have a basic understanding of how to do Webex, how to do Zoom. If there are problems, if you're not that savvy, having somebody in your office who can help you. Judge Chan was on a call with her the other day on a committee, new lawyer training committee, and she had mentioned that that very issue, and there is, I'm understanding, a Webex training on September 15th at noon to talk about how to deal with Webex. And I would encourage, if that's open to the public, I think it is, to get some training in that regard, because that's part of the competency issues. Just a couple of other points that I would mention. There's also marketing yourself as being able to continue to practice family law during a pandemic. Updating your bios on if you have a website, update your bios to so state. LinkedIn, update your LinkedIn to let people know that you're still in business and that you can do this. Blog posts, articles, things like that, to make sure that people know that you can do this. The other thing I think that Commissioner Minas had mentioned was on just the technical support, making sure if you have a Zoom or a Webex call with clients that you've done a trial run, that they have microphones that work, and that clients have access to computers. I think that that's a bigger problem for the lower income clients, the legal aid and pro se clients, and I think the courts are really trying hard to help that process. And the last thing I would say is in terms of leadership within your own firm, to reassure everybody that we don't really know what's going to happen, but we're making it work. And we have meetings every single week with our staff, Zoom meeting, just to check in and see how everybody is, how we can do things better, what is the narrative when clients call. And I think that that's really important within your team, whatever your team is. And that you also have your IT people make sure that you're set up to do the Zoom. There's Zoom apps that you can pay for that are more than 40 minutes. You want to make sure you have microphones on your desktops, all of those things. And lastly, I would mention, truthfully, just being flexible. we're going to have to be flexible. If you have problems with getting on, take a breath, you'll figure it out. Or, what we're doing for the last 30 days might be completely different for the next 30 days. And I think, maybe our new normal is got some good things about it. I think we all think that there should be. The thing that I think we all miss, hopefully, is the personal social part of really the personal connection with your clients, with your coworkers, with your friends. Some of us lawyers have started Zoom book clubs or Zoom lunches or cocktail parties. We just had a Zoom baby shower for one of our associates, and we made it work. And because I think the personal connection and the personal well-being, we really, really have to be careful. And so those would be my comments on that note.
Great. Thank you both so much. I have one question in the queue right now. So Russ, this is probably to you. I had a pro se party call me with questions regarding her hearing. Sounds like the notice listed in the court's address did not list any information about, oh no, it listed the address, but not anything about WebEx. So the client drove from 6th District to Farmington and was not allowed to enter her exhibits or attend the court in person. What are options for parties in that situation? And do all notices list if the hearing is on WebEx or in person? Mute.
So at least with me, I have control over what goes into my notices. And I'm not sure how entirely how other judges, especially other judges in jurisdictions outside of Salt Lake, Summit, and Tooele County handle it. But what I've tried to do is to be clear about how to send out notices in advance that it's going to be a WebEx hearing. The initial notice, previously what we were doing when the pandemic first began, was I was still scheduling the hearings as in-court hearings. But as we got closer to the hearing date, if it looked like we weren't going to be back open for business, we'd send out a notice saying that pursuant to the Supreme Court administrative order, we're going to hear this matter electronically. It's going to be a teleconference via WebEx, and give them the information. And then we'd also say the court would be sending out a separate email with a link as to how to join the conference. And I did that. We were sending out multiple notices because first we'd set it as in court, then we'd set it as a WebEx hearing. And then it became clear that this wasn't going to be going away very soon. And so now I just set them as WebEx hearings. And I'm going to go ahead and share what I've done here. This is a notice that we try to send out. This is a copy of in generally how the language is. It says, per the administrative court order, the hearing, I usually fill in a date there. And then the first thing we say is don't come to the courthouse. And then it says what to do if you don't get the link on how to join the conference. Contact my team through my team email address. If you're receiving this notice by email, it's because the court doesn't have an email address for you. Call us or email us as soon as you can so that we can get you that link so that you can join the conference. Then what I've done below, I tell them, I mean, sometimes hearings, there's multiple hearings scheduled on, stretched out over 2 or 3 hours on separate calendars. Join the conference when your original notice indicates your hearing date, your hearing time is, even if the email invitation says that the conference begins at an earlier time. And then as a last resort, if you can't join the conference or you don't have a computer, you can call in at this number and then enter the event password, the event number and the password indicated on the invitation. So I'm trying to do everything I can to let people know how it's going to happen and how to join and participate. And that's it's just an effort that we make. Also, what we're doing now with protective orders is when the respondent is being served, well, we give it to the petitioner when they come to court and apply for the protective order. And then when the respondent is being served with the temporary or ex parte protective order, they're also getting another piece of paper now that says this is going to be a hearing by telephone. And so don't come to the court. We've had people who don't follow instructions very well, obviously. And when they do that, we just get their phone number and have them leave the courthouse, and then we'll call them. As far as, I mean, certainly it's a problem if somebody's driving 150 miles just to file exhibits and they get to the courthouse and they're not being allowed to file their exhibits, especially because in the past, at least in Salt Lake, we weren't taking exhibits by email. But if we go back now, and I'll pull up the 2020, the latest pandemic order, it requires now that pro se litigants be allowed to file their paperwork via email. So we have to accept this. I just wanted to touch on one other thing too that I forgot to earlier, which was I'm looking at the Salt Lake. We're still under a red. The courts have their own level of pandemic risk color coding scheme, and the courts in Salt Lake City are still at the red level. I think all the 3rd district is at this point. And so when I look here at civil cases, really what I'm getting down to is paragraph 19, that the judges can conduct, and when they say other proceedings, these are all non-mission critical by remote transmission, including bench trials, if court staff is available and the proceedings comply with all applicable government and public health orders, et cetera. And then it says a bench trial by remote transmission requires the consent of all parties, but the court may proceed without a party's consent if the court determines consent has been unreasonably withheld, provided the other criteria are met. And I've seen that come up once with Judge Chon, Sharon, as you indicated earlier, and one of the parties did not want a trial, a divorce trial via Webex or remotely, because they felt that credibility was a big issue and they wanted that hearing to be held in person at the courthouse. But still, in the 3rd district, we're not having in-court hearings. I'm thinking this may go on at least till the end of the year, and then the big backlog is going to be the criminal backlog first, jury trials especially. And I think that the courthouse will open up in phases, and I don't think that family law matters are at the top of that list, family law trials. So these are just assessments that the parties need to make. In this particular case, it was an objection to my recommendation now it was set for an evidentiary hearing that's now been pending for a year. And it was an objection about my recommendation with respect to custody. And not surprisingly, the party who came out on the satisfactory end of that recommendation is the one that's saying that they want the hearing to be in person. All right, so these are the kinds of issues that arise. But I'm hoping that that others, and I'm just trying to be as clear as I possibly can about how this hearing is going to proceed. Get them notice and plenty of time. Check to make sure if we have email addresses for the parties. If they do, we can email it to them under Rule 5. If we don't, getting that notice out ahead of time so that it arrives in time. I mean, right now, the rule says we have 3 days for mailing, right? Who knows if a letter that we send out now is going to arrive beyond the 3 days. And so we just try to stay on top of it. And that also happened. This is also happening too with a hiring freeze. So the courts had these budget cutbacks, and they're not replacing some positions that have been vacated. And so in some respect, there's also shortages of help to get all this done. But I think we're managing pretty well in spite of all that.
Thanks. So here's a question. Russ, I'd like to ask you how the courts are handling it. And Sharon, I would like to ask you how you advise a client in this situation. I have an upcoming phone hearing, and the notice from the court indicated this was for counsel only. Can the court exclude my client from a hearing?
I've never done that. I mean, sometimes I have the parties muted because I just want to keep the background noise and the interference from making it difficult to hear and understand. Also, what happens a lot with people calling in that are parties rather than lawyers is they're calling in on their phone. and then they may be walking around, or the picture's moving back and forth, and that's also distracting to the hearing process as well. But as far as I'm concerned, and I think that's the reason why we're doing these by WebEx, and what we're also supposed to be doing is to be copying the link to the WebEx and putting it into the WebEx link for the not the participants but the attendees, and copy and paste that link into the calendar notes. And then every night at midnight, the court generates the dockets for the next day. And if you want to observe that hearing, you can go online to the Utah State Court's website, get that link, and then join. So we won't, you won't have the right to speak during the hearing, but you can at least observe. But I don't think that there's any basis for kicking somebody out of the hearing unless they're deliberately causing some kind of disruption and engaging in contemptuous type of behavior. The noise should be addressed too. And my practice is that when I hear noise, I start muting and unmuting people, and sometimes I have to go down 10. First I ask people to stop talking, and if that doesn't happen, sometimes there's traffic noise, wind noise, you name it. But I'll go through and try to find out where the problem is and mute them. Unfortunately, I don't have the ability to force them to always to stay mute, and they can end up unmuting themselves. I do have the ability in most instances to eject people from the hearing, but I've never used that feature. I think I may have done it once when somebody wouldn't stop. You know, I had an interesting thing happen yesterday too, where I called a case. I asked if anyone was present. Somebody on the phone, a pro se litigant, started speaking up. I started doing the hearing, and then it came to be. It came to be that the participant who I was talking to wasn't one of the litigants for the hearing, and that reminds me of an old case.
Russ, we lost your audio. Russ? Okay, Russ is frozen. Sharon, how would you advise a client where
at the arraignment?
Yeah.
Oh,
and it turned out to be the wrong defendant. He pled guilty to somebody else's charges. So these are the kinds of things that can happen.
So Sharon,
I'm sorry
how would you
if I'm
advise
still broadcasting. Maybe.
Oh, you're okay now.
Okay. All right. Okay.
I think, Lori, what your question was, and Russ, you froze for a minute as well. That's part of the whole technical difficulty. We need to be patient and flexible. The question was, how would I advise a client if the court said that they couldn't be present somehow during their hearing? And again, we've had that situation happen, and maybe it's still happening with phone hearings, specifically, I think up in, well, I won't say, phone hearings where there would be a hearing and the clerk or the judge or commissioner would physically be in charge of placing the call, and just getting frustrated that he or she was only gonna talk to two people, and she wasn't going to get the client on the line, or he wasn't going to get the client on the line. And I think part of that is just, the technology, the timing, and all of that. Hopefully some of the bugs have been worked out now. I think it's extremely important that clients be present if they want to be, and participate, even if they're just listening. And so if a judge or a commissioner indicated they weren't going to let our client, at least participate silently, I think I would suggest some other way to allow that to happen. And sometimes it may be that you have to have, and again, our office is closed. Occasionally we have very strict protocols of masks and everything else. Occasionally we might have a client come down to listen to a phone call. And we have a great big boardroom that we can socially distance. We can have masks on. Again, it depends on people's comfort level for safety and who they're around. If they have, if they're sick themselves, or they have elderly parents or whatever. But there is some flexibility, but I think it's imperative that clients be allowed to participate.
But that being said, we've all been called into chambers, just counsel into chambers, to have a discussion, and this could be explained similar to that type of experience. There's another
Yeah.
question that, oh, I'm sorry.
That's all right. I was just thinking. Go ahead.
That goes to the noise. And Russ, you touched on this a bit. And this was a Webex hearing, and there was a ton of background noise, and the judge was rushing through the hearing. So is there a way to say, we need to get the background, is there a way to address the court in a way that you can say, the background noise is too much, I feel like I'm not being heard, and could we please slow down a little bit?
Well, I really do try to go through and find out where it's coming from, and then either mute that person or to talk to remind everybody that we have multiple people. The problem just, it seems to increase exponentially the more people you have on the conference call and or on the WebEx event. So that's about the best I can do with it right now. Sometimes if there's a lot of people, I'll just mute everybody, and then I'll unmute the two lawyers that are presenting the argument. I know that the parties are there. We can unmute them if we need to, and so that I usually try to leave both lawyers unmuted the whole time, because there may be an objection, and I don't want to miss an objection because they were muted and they thought they got their objection in, and then it appears like I'm ignoring them. And so that's generally how I try to handle the hearings, is that if you're not a party or an attorney, you're going to be muted during that part of the event. And if it looks like one of the parties, and sometimes it's a lawyer, but not very often, where the feedback is coming from or the extraneous noise, then we work with it and try to get it fixed before we move on. But it does slow things down. I can't deny that.
Okay, now I have a question, and this goes back to something you both sort of touched on, and it's a question for both of you. It's different now that these are all virtual, hearings are virtual. How do you control who's in the room? So you're having a custody hearing, and the parent wants their kids to hear what's being said about the other parent, and so they're off screen. You can't see them, you can't tell their children in the room, but they're not supposed to be there. So does the court issue any instructions? And then Sharon, what do you tell a client if they say, well, I want my kids to hear this, when they shouldn't be?
I can start with that. This webinar, this YouTube webinar that was done by Christopher Melcher talks about that, particularly if you have just a background rather than, I think, Laura, you probably have a really nice University of Utah background, whether you're at home or not, I'm not quite sure. It's very pretty. But if you have a background and the client is there, you don't know who's in the room. I think the courts hopefully have protocols to question the litigants to make sure who is in the room. And I tell people that's one of the protocols I've learned, that they cannot have anybody else in the room unless those people are identified. There's also problems with if you have like a virtual background, people texting back and forth, or other individuals or lawyers and clients texting. There's a lot of problems like that. And I'm assuming that the court, if they don't have protocols for that, rules for that, that they are probably working on those. And I think Russ could probably speak to that.
Well, I make an assumption, I guess, a lot of times. Sometimes you just aren't thinking about it, and the hearing comes on, we start arguing issues, and then you may hear a background noise, and then all of a sudden you realize, oh my gosh, there's a child in the room, or something to that effect. And then I'll remind them. I mean, I had one where it was an attorney making the argument, and there's the client sitting on the couch behind the lawyer, and the child sitting there on the couch with the party. So that's not as difficult, of course, because you can see it happening. But certainly I could add that kind of language. There's already language in there about not recording the hearing and how that can be considered contempt and punished. Sanctions can be imposed, but it may be appropriate to do the same thing with respect to reminding parties that children, minor children in general, as far as I'm concerned, but especially children of the parties, should not be present to be able to hear or see anything that's going on during the proceeding.
Great. Well, we're out of time. Thank you, Commissioner Minas, and thank you, Sharon, so much for your participation and for all of the wisdom that you were able to offer. To all of you who were listening or able to participate, we will be sending out the written materials and a link to the YouTube channel where this was recorded by the first of the week. So thank you all for participating, and I hope to have you on another of our webinars in the future.